Hello, my name is Attorney Masa Sam Foray, founder of the Foray firm with offices in Chicago and in Houston, Texas. And I am back again today to answer all of your Illinois family law matters. So today's question is, what exactly is a guardian ad litem, a child representative, or an attorney for the minor child? So anytime there is contested custody, or what we now in Illinois refer to as allocation of parental responsibilities issues, then the court can appoint a third party. And that person is literally the court's own witness. And it can be on a motion that is done sua sponte, meaning the judge can make the motion him or herself to appoint a third party attorney to represent the best interest of the minor child in the litigation. A guardian ad litem, a child representative, and an attorney for the minor child are all dealt with and defined within the Illinois Marriage and Dissolution of Marriage Act, otherwise known as the IMDMA. And they're all distinctly different. So what is a guardian ad litem? Let's start first by defining that. A guardian ad litem is actually the most commonly used form of an attorney to represent the minor children in Illinois. In fact, once you leave the Chicagoland area, it's extremely rare to see a child representative appointed to the case. Most of the rest of the state of Illinois will appoint a guardian ad litem, or what we call a GAL. So a GAL, again, is the court's own witness. They are an attorney who will come in, a third-party attorney, so not mom's attorney and not dad's attorney, who will come in and do a thorough investigation. That investigation can take any number of different forms. It could include speaking to the parties themselves. If it is a child who is old enough to speak, it could be interviewing the child or the children in the litigation. It could also include speaking to any number of collateral contacts. And collateral contacts are friends, family, coaches, teachers, any number of different people who might have some light to shed on the situation and might have some helpful information to assist the guardian ad litem in doing what they are ultimately tasked with doing. And that is, number one, to help facilitate settlement, and number two, to write a report in order to give a recommendation about what is in the child's best interest to assist the judge in making the final decision about what's in the child's best interest. And so guardian ad litems are extremely powerful tools to use, because what you should know is that even if you have a child who is, let's say, 12 or 13 or 14 years old, and that child is old enough to speak for him or herself, that child may have very strong opinions about what they want to do and with whom they want to live. And if you search through my videos, I do talk about all of the factors that a court will consider in determining the best interest of a minor child. And certainly age and the wishes and desires of the child of the litigation are going to be considered. Nevertheless, it's very rare that a court will allow a child, no matter how old they are, to come into court and speak directly to the judge, or worse yet, to testify in the litigation. And that's simply because it's too emotionally traumatizing most of the time for children to go through. And so courts are very reluctant to do that. So they'll use a guardian ad litem or a child representative to go out and speak to the child if the child is old enough to speak, and to interview all other people, investigate the case thoroughly, and then make a recommendation to the court.